So, our next panel is on countercultural creativity, tattoos, and graffiti. And we have Marta Ilyadica, did I say it right? Yes. And Aaron Przanowski.
Well done.
Yeah, well, I've known you for longer. Time to practice. So, take it away.
Hi everyone, I want to start with a quote because I think it sums things up nicely. Graffiti writing breaks every rule, but within itself still has rules. This is what someone said to me during my fieldwork on graffiti. And what I'd like to do is to use my 10 to 15 minutes to provide some brief observations arising from my empirical research into the graffiti subculture in London to explain the nature of these particular rules. This included, effectively my fieldwork included interviews with a number of graffiti writers, also street artists, although I'm mostly talking about graffiti. And I should just say that obviously I'm incredibly grateful for being able to share these insights. I should also add, as you might be able to tell, that I'm not a US lawyer. I'm interested in UK copyright law, but I think that actually the insights would be more broadly relevant. So I don't have pictures, sorry about that. I pretty much spend a lot of time demonstrating why it would be infringing to show them. So what I'm going to be talking about is first looking at why graffiti creativity in particular gets pushed out of the realm of copyright law, so looking at illegality. I then want to look at graffiti creativity without copyright, and that is to look at the rules relating to originality and copying within the subculture, which might be summarized in the simple phrase, don't bite. And then to look at graffiti creativity that's in effect beyond copyright law. So this is to do with rules relating to appropriate placement, and that might be summarized perhaps not quite so neatly by the phrase, don't be a toy. And then finally, I want to talk very briefly about ways in which graffiti creativity might be brought back into the realm of copyright law. So my argument is, as I suppose you can tell, that rules exist within the graffiti subculture to regulate creativity, both in relation to their content of the works, but also their visibility or their location. So these are the two important elements to remember. So we're looking at regulating content, but also regulating where the creativity occurs. So how do we get then to rules that are both, or creativity that's both without and beyond copyright? Well, quite simply, certainly in UK terms, graffiti created without permission constitutes criminal damage. This is relatively straightforward. So effectively what we have is the criminal law disincentivizing the production of graffiti, or at least the production of graffiti that occurs without permission on walls and on trains. Copyright law, by contrast, would appear to incentivize creativity, but it's also pretty clear that it doesn't incentivize graffiti creativity. Graffiti writers, however, carry on. They create without reference or recourse to copyright law. And this is interesting because it seems fairly clear that, certainly in terms of UK copyright law, graffiti works would qualify as original artistic works. If we're looking at EU copyright harmonization and we apply the intellectual creation test, I think the result is the same. I should actually just add, I suppose, parenthetically, that I'm going to mention a few terms. I'm going to be talking about tags, simple signatures, throw-ups, slightly more complicated bubble letters, maybe with fill, maybe not, and then pieces, which are your lovely giant letters, possibly with characters, lots of shading, lots of different angles. But before getting to how we might regulate the content of these kinds of graffiti works, I think it's important to understand something of graffiti writers' motivations. So in other words, if copyright doesn't provide an incentive to them, for them to create, then what does? And I think effectively the currency here, or the reward, is fame rather than money. So graffiti writers aim to get up. In other words, they aim to make their particular name as visible as possible in urban spaces. But more importantly, they aim to make themselves visible in their own particular styles. And this is where the graffiti rules come in. They enable them to do that. They enable them to build their reputation, to build their name, and effectively to protect the style in which they write it. So, graffiti without copyright law, as I mentioned, we're going to be talking about originality. and the prohibition against copying. In other words, don't bite. Now, the really interesting thing here is that regulation without copyright actually looks a lot like copyright for graffiti writers. So they abide, or certainly in relation to my fieldwork, I found that they abide by a loose set of rules that broadly parallel both the subject matter and originality requirements in copyright law. And the two important norms here, the two important rules here are, first, there's a requirement that you write letters. So this is analogous perhaps to the subject matter requirement in copyright law. Second, the way you write your name has to be original. And this links nicely to the prohibition against copying. And this is analogous both to the originality requirement in copyright law, but also infringement by reproduction. So I'd like to focus on this second point in relation to originality and biting. So the letter style must be original. And I'd like to share how some of my respondents in the fieldwork talked about their creativity. So one writer in particular discussed it in terms of an aesthetic dialect. So everyone writes letters, everyone can use the alphabet, but the key here is how you actually use it to make something that's individual, something that's a little bit different or new or original. And he says it's a style, so you take it from the style commons if you like. So in the sense that, you know how sometimes people tell me that to them graffiti all looks the same? So the idea is there's a style commons, you're adhering to a particular style, but actually what you're doing is slightly different because you're using different angles, different colors. Everyone, you know, a bunch of people might use a Y, but they will draw that Y in different ways. So one writer said, he said, look, that's all part of the rules that people know, which is an important part of the scene. You can be inspired, or you know, maybe reference something, but you've got to have your own twist on it. You've got to be different. You've got to have your own take. So in other words, at the same time as graffiti writers are very much conscious of building on the creativity of others, they know that they have to do something a little bit different to make sure that they're not copying. So for example, and this again is something that you would have seen just by probably walking around, that there are lots of arrows in graffiti. But anyone can use an arrow. The key thing is that the way you use your particular arrow, say at the end of your name, is just that little bit different. So in other words, an example a writer gave, he said, look, you can reference the golden age of New York graffiti. You can do something that's very Bronxy, but it has to be a new variant on that. So I suppose while individual style for graffiti writers is informed by what's been described as a memory bank of different styles in your head, copying is prohibited. And I think it's worth, again, quoting a graffiti writer about why this matters. And again, I don't have very much time, so I think I'm glossing over some of the differences between old school and new school writers. I'm not going to go into it, but I think there was certainly the suggestion that this is not desirable, certainly not copying, exact copying. This writer said, well, look, why does it matter? It matters because graffiti is ultimately an expression of self. And if you're expressing yourself, no one else is you. And if someone else is claiming to be you through their style, then that's not cool. So we have this sort of personality justification. There's also a labor one. It says if you've dedicated a big portion of your life to learning this craft, spent years developing your style, and then someone else comes along and says, I'm going to take that without putting any effort in, it's offensive. It's really offensive. And yet, even though there's this suggestion that obviously you're not supposed to bite, it's difficult to actually tell exactly where this boundary lies. So for instance, someone else says, sometimes you're so good that everyone's going to copy you. Sometimes you're so famous. Sometimes a piece appeared in the Bible of Graffiti Writing, Subway Art, published in 1982. Everyone's going to know that, oh look, you're taking a little bit of Futura, and that's fine, as long as you're actually putting in a little bit of yourself as well. I mean, I think the key thing to take from the don't bite set of rules is that these rules are important for the development of the graffiti culture. So graffiti writers are conscious that, and one writer described it really nicely, he said, look, we're contributing to a library of style. The reason you conform to a particular set of aesthetic expectations but then add your own twist is that you're consciously moving or developing the culture. So that's copying. We then move on to what I've termed graffiti writing beyond copyright law. And that's to do with location and visibility. So as I said, in terms of motivations, you want to have style. So we regulate content in relation to the prohibition against biting. You also want to be visible. The more visible you are, the better. The more times people see your name, that's great. Your respect. You're going to gain more respect. The really fascinating thing here is that there are rules regulating appropriate placement. So we have rules regulating where creativity occurs. And I think this doesn't really have easy parallels with copyright law. And I think there are two sets of rules that are important here. The first relates to permissible or appropriate uses of other people's real property. And the second addresses scarcity. So it's to do with determining when one writer can go over the work of another when you have one wall and not much space. I'd like to focus on the first point in relation to placement on other people's real property. Now, my fieldwork identified a major concern with respect for what was called personal property. So, and this is why it's interesting, your motivation is fame, and yet you still won't find graffiti in places that would be really, really obvious, like cars or lots of houses. So I mean, I think the really interesting question about graffiti is not where you see it, but where you don't. And this is in part, I think, because creativity is curtailed on the basis that it would not be appropriate to put it in certain places. So churches, houses, cars are off limits, while certain public and also private commercial properties weren't necessarily. As one writer said, there's definitely ethics involved. The theme of respect across the board in my fieldwork came up particularly strongly with respect to churches and religious places. So while you didn't have writers claiming to be religious at all, they did claim a basic respect for people and not wanting to upset someone unnecessarily. Or as one writer said, look, I'm sure we worked it out for ourselves. At 13, I might have tagged a church, but if you're an actual graffiti writer, then you wouldn't. And another writer said, similarly, people's houses are a no-go. You respect someone's space. Commercial vehicles, trains, all is fair game for the most part. And sort of I pressed on this point asking, but why not people's houses? And again, the answer comes back, out of respect for people's personal space, I guess. This norm is sort of underpinned by this sense of empathy, and I don't suppose it will surprise you to find that it doesn't actually extend to large commercial enterprises. And the explanation there was that you feel like so long as it's not a crime against a small business or an individual, it's a crime against a big company that makes big profits, well then that's something that I can overlook morally. Okay, so they're the rules effectively, or some approximation of them. They regulate content and also visibility. I want to just briefly mention this notion of commodification or bringing graffiti back in, because I don't want to suggest that copyright will never apply to graffiti creativity. Where you have graffiti writers participating in the art market, then copyright is going to apply. And indeed, when I asked about this, it became fairly clear that while graffiti writers are perfectly happy for you to take photos, put them on your blogs, to share it, and this might contribute to your fame, it wouldn't be appropriate for you to then sell it or to make money from it. Or in other words, if someone's making money off your work, then that's wrong, I think. So I suppose the broad conclusion here, and I think mine is much the same as with the other really fascinating talks, is that creativity, or in this case countercultural creativity, exposes the limits of copyright protection, or certainly the incentive justification. But what I want to leave you with is actually a slightly different observation, and it's a quote or a short meditation on graffiti creativity from a writer. And in describing his practice, he said, for me, it's like there are 3 pleasure steps. The first is where you find your style. The second is where you do it for real. And the third part is when you see the thing you've made, when you see it in the daylight, in the street. And I think this is creativity both without and beyond copyright, and it's perhaps also the reason that copyright doesn't touch it. And why you have these alternative norms, because these norms can deal with the process, and they can, in some sense, take into account the pleasure of creating rather than focusing on the product.
So I'm going to be the difficult Mac user who has to connect his own laptop. So give me just a moment to pull that feat off. So I'm going to be talking about the tattoo industry. So I don't know how much you know about the tattoo industry. I know quite a bit about it, having spent a lot of time talking to people who work in this field. But if you don't know about the tattoo industry, you are increasingly at risk of being in a minority of US citizens. About 20% of the US population has at least one tattoo. That's 65 million people. And if we limit our consideration to people who are under the age of 40, that percentage doubles. And we're talking about nearly half of the US population. I'm actually going to have to undo this. It needs to go on the other side. So I think we have to, sorry. There we go. So that's a lot of people with tattoos in the United States. And so it's a big industry, right? We're talking about billions of dollars at stake in the US tattoo industry. All right, hopefully this is gonna hold. Oh, is something happening here? Yeah, thank you. There's a play button here somewhere that I can't quite see. All right, there we go. So multi-billion-dollar industry, lots of creativity going on here, right? All of this is driven by the creation of new works and sort of the copying of existing works. So you'd imagine that copyright law plays some role in what's happening in this industry. With a handful of small exceptions, it turns out it doesn't have much at all to do with what's going on in this industry. Getting weird networking prompts. Okay. So my project here is largely kind of figure out why that is, right? So culturally, we've all got some idea of what the tattoo industry is or what it's about, and it's like something like this, right? Garish, neon sign, sketchy neighborhood, unnecessary punctuation, disregard for grammar. And we think we know what happens when you walk into a tattoo shop. It kind of looks like this. There's a bunch of images on the wall, and you kind of look around and you find the dragon that speaks deeply to your soul. And you pick out that dragon, and somebody puts it on your body, and you pay them. And you pay them in cash. These kinds of tattoo shops are based on a model that's sort of dated to the period between kind of World War I and World War II, when tattooing sort of experienced its first big boom in the US. And these places are still around. There are thousands of them around the country. They're called street shops today. It's sort of the lower end of the tattoo market. Around the 1960s, tattooing started to change, and those changes really took off in the 80s and 90s and 2000s. But the basic change that happens here is that tattooers become much more sort of artistically inclined. They become much more interested in original expression rather than just sort of recreating these pre-drawn flash images. That's what this stuff is called. Clients start to have higher expectations when it comes to originality and quality. And so it drives a lot of innovation and a lot of personalization in the tattoo industry. And so we end up with stuff like this. This is custom tattooing, right? These were not images that were picked out from some book or off of a wall. These are people who sit down in consultation with their artist, come up with ideas and imagery and styles that are sort of specific to them. They schedule appointments for these kinds of tattoos months in advance. They pay hundreds of dollars an hour for these services. Very different from sort of the, I think, common conception of what happens in the tattooing world. And this rise of custom tattooing is important because it introduces a new layer and a new scope of creativity and sets the stage for people to have disputes with each other about, did you copy my design? If we're both working from the same pre-drawn flash, that's not really a concern. And so we start to see the potential, at least, for disputes over ownership and copying of these kinds of works. Here's one sort of, one dispute that kind of falls in this category. So I don't know if people remember this, but a few years ago we had this lawsuit where Universal, I think it was, the studio that produced The Hangover 2, was sued by Mike Tyson's tattoo artist for recreating Mike Tyson's distinctive facial tattoo, right? Threshold question here is whether or not tattoos are even protected by copyright law. I don't want to spend a lot of time on this because I think the answer is very, almost certainly yes. What do we need to have copyright protection? We need to have originality. Some tattoos, most tattoos are original. This one, in fact, might not be. That, I think, is an issue that would have been interesting to determine in this case because it's derived from ancient thousands-of-year-old Maori designs. But we have originality most of the time, and we definitely have fixation, right? These things are much more fixed than lots of other kinds of works that we see in the world of copyright law. So I am going to take a position contrary to the position of David Nimmer, who, as a paid expert in this case, offered an opinion that tattoos could not be protected through copyright law. Interestingly, a position that conflicted with what he had been writing for a long time in his authoritative, imaginary, air quotes here, copyright treatise. So I don't want to spend a whole lot of time talking about this question. I think we can assume that tattoos are the sort of thing that copyright law protects, and if people want to come back to that point, we can in a few minutes. So we've got a kind of work here that receives copyright protection. There's no major barrier here. So we might expect them to use that protection, and it turns out they don't, right? They don't sue each other, tattoo artists. They don't sue their clients. They don't sue anybody, with a handful of exceptions that we can talk about. Instead, they rely on a set of informal social norms to figure out how to structure their relationships and deal with each other and deal with their clients. So one of these norms, the first one I want to talk about, focuses on the autonomy of the client. Nimmer's big concern, which I think is a legitimate concern in the Tyson case, is what happens if there's a copyright in a tattoo and the tattoo artist is the one who holds that copyright? Do they get to assert control over what a person does with their own body by virtue of copyright law, right? That would be a problem. It turns out there are lots of ways of addressing that problem doctrinally, but we don't even need to get to that point because the chief norm that operates the relationship between the tattooer and the client recognizes the autonomy interest of the client, right? So this is a quote from one of my interview subjects who sort of illustrates this point in somewhat colorful language, why it is sort of antithetical to the entire enterprise of tattooing to assert control over someone else's body. Once the image is applied to the client, once the client walks out the door, it's part of them, right? It's their thing to use as they see fit. And there's really no ongoing control over the tattoo as applied to the client's body. So if they want to post a picture on Facebook or Tumblr, or they want to walk around in public, engaging in a public display by wearing their, short sleeve shirt or whatever it might be, those are all things that the client is totally entitled to do. When we see discomfort in the tattooing community surrounding these kinds of uses, that happens when the use is disconnected from the body. right? So if you take an image, you get a tattoo, and you go to your friend who's a graphic designer and say, make me an Illustrator file, right? Make me a vector image that I can slap on a t-shirt or a coffee mug. That sort of transcends this respect for client autonomy. The interesting borderline cases, and this is where litigation has happened recently, deals with video game depictions. So we see professional athletes in video games, and for the sake of realism, their tattoos are included. There we've seen a couple of examples of tattoo artists not suing their clients, but suing the makers of those games. And I think the explanation for that is, well, a couple of explanations, right? One is probably obviously economic. The other is that use is really at the border of what we can consider a use that is connected to the client's body. It's not the client themselves that we're seeing, it's sort of a digital representation of them. And so I think this norm starts to break down a bit there. So this is about the client relationship. What about the relationship between tattooers themselves? Tattoos are really widely available. Images of tattoos are widely available on the internet, right? You go to Facebook, you go to Tumblr, there's a lot of images of custom tattoos. And that's led, I think, to an increase in copying, right? So we see this kind of copying going on where you have a nearly sort of identical replication of an image. And this is in violation of these community norms, right? Everybody agrees this is wrong. Everybody agrees this is not the thing to do, but it does occasionally happen. This is a really sort of obvious, literal example of this kind of copying. Sometimes it's a lot harder to figure out whether something is a copy or not, in part because of the long, rich visual history in the tattoo industry, in part just because of the same idea expression problems that we're used to in copyright law generally. So I talked to people about this, and one of the people I talked to says, in that gray area, there isn't a line until someone draws it, right? But that's always retroactive. The line is identified as being crossed after the fact. So there's a difficulty here in identifying what counts as a copy, in identifying that line separating idea from distinction. And to me, this sounds a lot like Learned Hand in 1930, right? That's not intentional, right? That's not a result of studying Nichols versus Universal Pictures, but there's something intuitive going on here. We've also got flash designs. Flash has been a staple of the US tattoo industry for a long time. It's still important. People still make and produce and sell new flash designs, but everybody understands implicitly what can and can't be done with flash, despite the fact that there's no end user license agreement here. If you buy it, you get to tattoo it on as many clients as you want. You get to make changes. You can create derivatives based on it. So these aren't written down anywhere, but people understand this rule. Then we've got the relationship between the tattoo industry and the art world generally. And generally the approach here is if you bring in a painting, a photograph, an illustration, it doesn't matter if it's in the public domain or not, we will tattoo it on your body. And if we won't tattoo it on your body, it's mostly because we think it's boring and not interesting. But if you want it, we don't. There's no sort of there's no norm against copying from the art world. Sometimes they talk about this in terms that sound shockingly like transformation in the fair use analysis, right? When you reinterpret it, it develops a new meaning and a new power. Again, this isn't coming from a person who's read Campbell. This is just sort of an intuitive understanding here. Sometimes it's purely a matter of kind of insider-outsider dynamics. Not a huge surprise there. Really quickly, I got a few minutes left. I want to talk about where I think these norms come from. One explanation is cultural. People in the tattoo industry tend to sort of see themselves as outsiders. There is an economic benefit to sort of cultivating that outsider image because that's sometimes, I think, what clients are attracted to. They also don't have a great history of interactions with the formal legal system. The last statewide tattoo bans were lifted in South Carolina and Oklahoma within the last decade. They still face really tough local zoning laws in lots of places around the country. A federal appeals court did not recognize the First Amendment interest of the tattoo industry until 2010, after lots and lots of cases said this isn't actually speech. So it doesn't shock me that they don't run to the court system to try to sort of defend their interests. Part of it is also economic. There's a collective self-interest in maintaining these norms. Clients expect original one-of-a-kind tattoos. If they're worried their tattoo is going to be ripped off or that their tattoo is a rip-off, they're not going to be willing to pay as much because that's not what they're looking for. There's also a concern that if we start limiting what clients can do with their tattoos, maybe they're less interested in tattoos. Maybe they'll express their youthful rebellion, like they'll go buy a motorcycle instead of getting a tattoo because they can do what they want with their motorcycle. The other economic explanation here, I think, is about limiting competition within this industry. So the tattoo industry relied historically on trade secrecy. Secrets about equipment and technique and like how to mix the pigments and where to buy them. You had to build your own tattoo machine, right? It's like this sort of like Jedi training going on. That has all gone away. You can buy, I could buy a tattoo machine on the internet and have it delivered tomorrow, watch some YouTube videos, and give all of you terrible tattoos, like whenever you want, right? So that we can't rely on the trade secrets to keep out new competitors, right? And these secrets were only revealed to apprentices who offered free labor in exchange for access to this information. So now we raise the bar by insisting on not only you have to have technical skill, but you have to draw a new custom design for every client you're going to see tomorrow, right? That limits entry into the high end of this market in a way that I think is really beneficial to the people who are already part of the inside of the insider-outsider dynamic. Other explanations, of course, I'm happy to talk about them, but I'm more than out of time, so I'm going to stop for now.
Thank you. Personal story, when I read Aaron's draft about 2.5 years ago, I found it so compelling that I got my first tattoo. So we have time for a quick exchange. Could we maybe set up the other computer again while that's happening?
So what do you want to talk about? The thing to me that I think is really interesting as I was sitting here listening to you talk and thinking about this work is these are both in very different ways site-specific kinds of expression. Mm-hmm. Graffiti in a very public forum and tattoos generally and hopefully in a more private forum. I'm wondering what you think that tells us about the relationship between the creator and, for lack of a better term, like the audience. Right? The client is driving a lot of what happens in the tattoo industry, but I wonder if you can talk about kind of how graffiti writers think about, like, who are they creating for?
Yeah, that's really interesting because as I was listening to you and you were talking about the client autonomy norm, I was thinking it's really interesting how you have this collaboration between the tattoo artist and the person. And I was thinking of the difference perhaps with graffiti writers, because if your aim is to be well respected, effectively you're writing to be seen by other graffiti writers, so you become more famous. This is something that I discussed in the fieldwork, and it was quite interesting that although it's obviously incredibly public, there are two things to note. The first is that sometimes it's visible, but only in the nighttime. So you have, for instance, people painting on roller shutters because they know that when the roller shutters come down, the kinds of people that they might want to see it are the ones who are going to see it. You suddenly in the nighttime have a different city and therefore a different audience. Mm-hmm. But the second is the one where a number of writers said that actually we don't write for the public, but with particularly prolific writers, and for anyone who's in London, there are the names that you would recognize. They say, well, one of the lovely quotes was something like, look, we don't do the work for the public, but these works say something to the public about freedom. They say, I'm going to write my name anywhere I want in this city, and that's freedom. But that's as close, I think, as perhaps you might get to directly wanting to engage.
Yeah, so I mean, the way this sort of expresses itself in the tattoo industry, I think, is in part is there is a real recognition that a deep sense of personal ownership of a tattoo that you create and put on another person's body and walks out the door and you may never see again is not a worthwhile exercise, right? Don't become attached to these things. And I think that explains the, like, in part, the autonomy norm. There's this permissiveness there. I would imagine that there's a little bit of a corollary there in the graffiti world, not because you're not going to see the thing again, but because for most of this work, its lifespan is limited and hard to control. I mean, do you think that's true?
Yeah, I thought it was interesting what you were saying about taking the photo. So you take a photo, you have a record of the thing that you've made, so you know that you've done it, but that's perhaps the only thing you'll have. And actually, I think that's something that's similar with graffiti, because you're right, it might disappear. On the other hand, if you're really good, you're going to put it up really high, somewhere where it's less likely to disappear. But yes, I think.
Yeah. So, do we have a couple more minutes, or should we? Okay. So, the other thing that I wanted to hear you talk about more that I really love in the paper, which is related to this, and maybe you can like briefly summarize the sort of norms around going over other people's work, and the way that what I think is interesting about this is the way in which it suggests there's much more comfort within the graffiti community surrounding making aesthetic judgments about work. I think that's really interesting. So I was hoping you could.
Yeah, and that's actually reminded me, so I don't forget at the end to ask you about sanctions in relation to tattoo norms. So when I was talking about placement and there being different rules, I think where space is scarce, this isn't necessarily going to come up a lot, but there are particular norms that arise in relation to when you might be able to go over someone and when you can't. I mean, just very briefly, you remember how I mentioned that there's the tag, the throw up, and the piece? Roughly speaking, a piece goes over a throw up goes over a tag. The idea being is that you're doing something more complex, so you're making a aesthetic judgment that actually this is going to be a little bit better. On the other hand, if you're particularly famous, your tag probably trumps someone's really poor piece. So yeah, you make this aesthetic judgment. I can go over it, but only if I'm confident enough that actually what I'm going to do is going to be something that's going to be better. And there's a particularly important exception to this that I want to mention. If it's a memorial piece, that's absolutely a no-go area. It doesn't matter if it's a tag. If the writer has died, it would be absolutely the worst sign of disrespect to go over it. But apart from that, absolutely you're making aesthetic judgments.
Yeah, Aaron, maybe you could talk about sanctions
Yeah.
a little.
Oh, yeah, sure. Yeah, so, you know, the sanctions in the tattoo industry are in some ways less interesting than you might imagine. You know, the primary sanctions are really sort of internet smack talking, I think is probably the best way to describe it, right? So there is, you know, an opportunity for a tattooer who thinks they've been wronged to make that known within this community, to and sometimes open the copyist up to you know, social sanctions in terms of isolation within the industry, in terms of feeling ostracized. I mean, I think this is pretty consistent with what is seen in other sort of norms-driven communities. There's like sort of talk about violence. It's not, I don't think it's a real phenomenon, and it's sort of described as something that, oh, that's what happened like in the 60s when tattoo shops were run by biker gangs. You'd copy someone's tattoo and they'd come over and break your hands. That stuff doesn't happen. Half these people have MFAs at this point. Like they're not, yeah, they're not that violent.
All right, let's open it up to the audience. Any questions?
So I wanted to follow up on the sanctions issue. So what's surprising to me is it seems like in tattoos from your paper, the sanctions are really weak. And I'm curious what the sanctions are in the graffiti setting as well. But what it makes me think about the big picture story of norms is that there's sort of the traditional story that people obey informal rules because they're afraid of sanctions, right? But then there's this other, I think, story of cooperation, which is that people just spontaneously follow norms because we have an instinct for cooperation. And I'm trying to figure out, in both of these cases, is the coalescence you see around the rules you've described a story of people being afraid to deviate because of sanctions, or is it a story about people just sort of naturally coalescing around norms because that's an instinctive thing that we do?
I'm happy to field this one first. I don't really have much evidence to base this on. I think when it comes to getting, relying on interview data to get descriptions of people's behavior, I think it's really good. I think when you're relying on interview data to tell you about people's motivations, I'm less likely to treat interview subjects as sort of reliable witnesses about their motivations. So I don't have much to base this on other than kind of my intuition here, but it seems to me that the compliance with the norms in the tattoo industry is driven by kind of a process of internalization, right? They see this as part of their identity. It's not, I don't break the rules because I'm scared of sanctions. It's, I don't break the rules because that's not what we do, right? We are sort of a self-defining community. And you're right, the sanctions are not particularly strong here. Oftentimes, there are no sanctions whatsoever, right? People are willing to recognize that copying has happened and just say, yeah, I think less of that person, but I'm not even going to bother saying anything to them. So I think it's about your own kind of self-conception in a way that is that outweighs any real fear of sanction.
Yeah, it's actually very similar. So what you were talking about, sort of gossip or shaming, the threat of violence, but not necessarily violence. On the internet, absolutely, the forums, some of these are brilliant, especially where the US and European writers are having goes at each other. I mean, it's highly entertaining. So I think to your point about cooperation, I think there is something in that, and exactly what you said is, if you're a graffiti writer, if you belong to this community, then there are particular things that you wouldn't do. So there is perhaps, I think, an instinct for cooperation. But I think the one sanction that's probably different is, so I mentioned going over, that also functions as a sanction. So looking at a wall, you won't necessarily know why someone has gone over someone else, but if someone's done something wrong, you hurt them by destroying their works.
I have one observation and one question to Marta. The observation is, I find it fascinating how in both presentations there was a very strong sense of concerns about personality and self-agency, not only in the sense of how the artists see themselves and the rights that they assert, but also where they stop and respect the self-agency of others. So in Marta, or you don't put graffiti on individuals' homes or those places, that's beyond. And in the tattoo, you don't assert the body of your customers, that's totally beyond. And it's interesting because, I mean, at least I think in North America or the Anglo-American world about copyright, we don't have rich vocabulary of thinking about copyright in those terms. And that's something that can be quite insightful. The question for Marta, so you describe the graffiti world as something like that parallels a lot of the details of copyright, in a sense, not only about the criteria for protection, but also about the limitation and exception. Now, if that, could that be kind of natural experiment, saying that's something that just develops totally in isolation from copyright, and we just observe this natural experiment and see, look, when we let those things grow organically, they would have those features because there are some optimal balance when having those features in a copyright system, which would be cool. But there also, I think, a possibility that it's not, even though they may not be thinking about copyright or don't see themselves as knowledgeable about copyright. The norms of copyright are so deeply ingrained in our society, even if people don't realize that they are. So they are basically adopting the rules of copyright law without necessarily knowing that that's what they're doing, and which isn't a natural experiment. So that's
a really interesting point. I think maybe what you're talking about and what I'm talking about is maybe the underlying justifications for copyright protection that you might have. So, but in particular, I mean, I think it could be right that we have a culture more broadly that's concerned with authenticity, or being able to place your name on something, and this is something that writers might associate with copyright. Very occasionally, you see the copyright symbol on a graffiti work, but it's not because they're asserting themselves as copyright authors or owners. It's simply a way of saying, actually, this is mine. So maybe that's something that's shared, but I don't have data to say one way or another whether it's obviously influenced by copyright. Often I would ask, and it would be met with a blank stare, like, why would we use copyright? We have our own way of doing things.
Well, thank you both so much. We're unfortunately out of time. We're going to move right on to the next session, and I'm going to ask Erin to keep time, since I'm in it.
So up next, we have our co-organizer, Kate Darling and Kumi Arewa, who are going to be talking about two very different film industries.
They're not so different in many ways.
Okay, so first of all, I wanted to say it's a pleasure to be here. As many of you know, I started my academic career here, and it's always a pleasure to come back and see old friends. I also wanted to thank Erin and Kate for organizing this very interesting conference. Just give me 1 second. I need to put my timer on so I can monitor myself. Okay, so I'm going to talk about the Nollywood film industry. So the title of my paper is Outside the Mainstream, Nollywood Copyright and Creativity. So I first want to do an informal audience poll. I'm just curious, how many people have seen a Nollywood film? So we have a couple of Nollywood film, 3 or 4 people that have seen Nollywood films. Nollywood is a really fascinating example of creativity because it sort of came out of nowhere. In the early 1990s, Nigerians started to produce a lot of films. So I'm going to talk about 3 things: the rise of Nollywood, then I'm going to try in my 15 minutes to talk about Nollywood and copyright, Nollywood and cultural diffusion, and Nollywood and creativity outside the mainstream. I may have to skip things a little bit because I think I was overly ambitious last night in either how fast I could talk or how much time 15 minutes really is. So what happened with Nollywood, it came out of nowhere. And the thing that's really interesting, if you'd asked someone about African film 30 years ago, they would have immediately thought about the beautiful films that come out of French West Africa, Semben Ousmane, God's Little Bits of Wood, or Black Girl, which are these beautiful, gorgeous, I don't know how many people have seen them. They're externally financed. They're very expensive films relative by African standards, given the level of income in most African countries. And they were largely externally financed. A lot of the French West African films were financed from France. And they're beautiful movies, but they have very little audience inside Africa. I actually saw them as an undergraduate taking African studies and African history courses, and they're beautiful films. However, they're not really mainstream films within Africa. So if you'd asked people 30 years ago about where would an African film industry arise, they probably would have said something like Senegal or Mali, somewhere where there was actually established film production. The thing that's really interesting about Nollywood is it sort of came out of nowhere. Nigeria became the leading producer, one of the leading producers of films in the world, largely based on people's access to digital film technologies. So people just started to take cameras on the street and make films. And as it turns out, there's a huge number of people in Nigeria. I'm not sure we know exactly how many, but probably between 150 and 200 million people. So it obviously has a very large potential domestic audience. This was during a time period when there was a lot of insecurity in Nigeria, so people couldn't really go to movie theaters. In fact, there were virtually no movie theaters in Nigeria at the time period. So if you think about a video film industry emerging in a place where there's no copyright enforcement, there are no theaters, and there's little or no existing film production. There was some film production, so there are some older makers of films that are still in Nigeria, but Nigeria was certainly not an important locus for the production of films. So now I want to talk about that within the perspective of copyright, but I want to talk about a few data points. By 2009, an estimated 11,000 films had been produced in Nollywood, with global distribution in Nigeria, Africa, Europe, North America, and even Asia. I've heard about, although I haven't visited, if you go to any African market anywhere in the world, you can probably find these films. So you should try it sometime. I often go, whenever I'm in any country and I see an African market, I go and try to see, can I find Nollywood films? And I've ultimately been successful. I've never seen an African market where they're not Nollywood films. So Nollywood has become representative of African commercial films in the digital era. So I want to talk about why this is important and what the implications of this is for how we think about copyright and creativity. So the thing that's interesting is that they're not just watched in Africa, they're not just watched in Nigeria. They're watched by Africans all over the diaspora. So often one of my favorite questions when I get an African taxi cab driver, anywhere in the US, for instance, I ask, well, do you watch Nollywood films? And there's some generational differences, but often the answer is yes. And I sort of ask why. And they say because it reminds me of home. It gives me a sense of community. And the thing that's interesting, I was talking to a Nigerian friend about Nollywood films, and I sort of said, well, they're sort of like B movies. And she said, no, I really think they're sort of like D movies. The technical quality of these films, especially the early films, was not very high. Those of you that have seen Nollywood films, the sound editing quality, it's certainly not Hollywood films by Hollywood measures, especially in the earlier part of the Nollywood film production cycle. But nonetheless, they found a huge audience despite the lack of technical quality. And one reason it was easier is that they really weren't shown in movie theaters. Now, increasingly, we're seeing as Nollywood matures, we're seeing more expensive films. The older films were produced very, very quickly, right? There was no copyright enforcement, little or no copyright enforcement until very recently in Nigeria. And a significant degree of that enforcement has been driven by the fact that Nollywood people are saying everyone is pirating our films. Now, it tells us that we have to see piracy in several different lights. Piracy is what made Nollywood, right? Because the reason why we have distribution in Africa, Europe, the United States, Asia, is that pirates just copied the films and distributed them very widely. At the same time, with the early Nollywood industry, that really helped spread the Nollywood brand recognition. It put Nollywood on the global cultural map. At the same time, as Nollywood matures, people are recognizing a different value proposition because people are saying, if I want to invest more money in film production, something that's moving Nollywood perhaps closer to a Hollywood model, I actually maybe need a little bit of copyright protection. So I need copyright enforcement. I need the ability to actually get these pirated films off the market. But it does highlight the early Nollywood successes are very much piracy was very much an early part of Nollywood's successes. So as we think about creativity, we have a film industry, a major film industry in the world that arose with absolutely no copyright, or little or no copyright. So Nollywood represents a natural experiment in creativity in the absence of copyright. And it's a really interesting and important experiment. So with that background, talking about Nollywood generally, I want to talk about the three things that I mentioned. So I want to talk about Nollywood and copyright, Nollywood and cultural diffusion, and Nollywood and creativity outside the mainstream. One thing I want to emphasize, many people talk about how Nollywood democratized cultural production. And that's something that's really important to think about in the African context. During the colonial period, Africans were not permitted to make films. So they were definitely excluded from the realm of film production. Even in the post-colonial period, technologies of film production, it's very expensive to produce traditional films. That's why UNESCO in a report said Nollywood may offer an opportunity for developing countries to think about developing film industries, because most film industries in the world, we don't always recognize it as such. Virtually all of them are heavily subsidized by either local or federal governments. So it's very hard to have a film production industry without subsidization, largely because films are so expensive. So if we look at countries like New Zealand, countries like the United States, there's extensive subsidization of film production, Canada as well. Nollywood is one of the only commercial industries in the world that actually emerged without any kind of government subsidies. And the thing that's interesting, when you look at Nigerian film production volume, it's really astounding because Nigeria outproduced, by the mid-2000s, Nollywood outproduced Britain, Italy, Spain, and Germany by 8 films to 1. It averaged 4 times as many movies a year as France and doubled the output of China and Japan. It became second to Bollywood in the production of the number of films produced, and again, some 11,000 films were produced between 1992 and 2009. So that's an astronomical amount of film production in an area where there was basically little or no film production prior to the early 1990s. So I want to talk about Nollywood and copyright. So Nollywood demonstrates to us that film industries can emerge, certain types of film industries can emerge in the absence of copyright. Now, Nollywood has particular configurations that are shaped very much by the absence of copyright. So for instance, you might ask, well, if people can't exclude people from copying their films, how do they actually make money? Well, they make films very quickly. Some Nollywood films are made in as little as 10 days, so that's a really fast amount of time in terms of filming, not very much post-film editing. And then you have to try to make money as quickly as possible before the film is copied. So what people do, one reason there's so many films produced, people sort of produce a lot of films. They're not really sure what films would be successful. So you tend to produce a lot of films, and then there tend to be a lot of sequels. So a film you might have seen, there's some very famous comedies, and they'll be like number 1, number 2, number 3, number 4, number 5. Because if one is successful, then you quickly produce 2, 3, 4, and 5 because you know that there's a market for the film. Before you actually establish whether your film is successful, you don't really know whether there's going to be a market. So you might not be inclined to invest so much money in that film production. One of the things that's also interesting, in addition to a lack of copyright enforcement, there's actually not a lot of, the business infrastructure in Nigeria is not so well suited to the development of a film industry. Nigeria, like many countries in Africa, has a huge informal sector. So people don't generally sign contracts. There's a lot of informality. People don't generally allocate rights in the way we think about it in the United States context, which means that even if you were to actually put more copyright enforcement in Nigeria, there would have to be some things that would be done with respect to rights allocations that I think the industry is working on, but it hasn't quite fine-tuned. So that's a real impediment to sort of thinking about Nollywood as it matures, perhaps being more like Bollywood and Hollywood, where you definitely do have a lot of rights allocations. Nollywood films are very much driven by producers and distributors, so because they have a lot of control over how and when films gets distributed. I mean the formal official distributors, not the unofficial ones that copy after the fact. So Nollywood entered onto the cultural map because of the unauthorized distribution, because of the pirates. So pirates are an inseparable part, as I mentioned earlier, of Nollywood's successes. However, as Nollywood matures, we see that there are problems. So it points out that we can't think of cultural production in a static way. In some environments, even when even in sometimes low copyright environments serve industries at certain points in times, but when industries mature, they may actually need more copyright protection. Oh, I really need to talk a lot faster. And that may require different IP frameworks. So just a couple of brief, in my remaining 5 minutes, a couple of brief comments about my other 3 points I want to talk about. It's really important that we think about copyright as a cultural gatekeeper. In copyright discourse, we all tend to acknowledge the reality of cultural diffusion. At times, we don't really sufficiently, in my view, acknowledge the implications of cultural diffusion for copyright. We sometimes tend to have a very static view of cultural material, and obviously, as lawyers, we tend to focus on issues related to proving ownership and demarcating. One way, infringement is basically a demarcation of an inappropriate transgression onto a property right. I think what constitutes a transgression essentially determines who has cultural authority to change works and to change existing content. And those ways we think about cultural authority are very much imbued with conceptions of status and power. So in the early 19th century, we had a lot of people using cultural content in the music industry, for instance, and other industries from sort of urban and ethnic sources. And they often characterized those sources as folklore, which means they had cultural authority to use it, not compensate people. So how we construe cultural authority has really important in those kinds of contexts. So part of my work in Nollywood is seeking to think about how we think about cultural diffusion. Some of my earlier work focused on borrowing and diffusion practices by which works are copied. I think we also have to look at who it actually has authority to copy and who doesn't have authority to copy and who are the people that are copied. So one of the things I'm looking at more in this Nollywood piece is focusing on that. Last and not least, I think Nollywood is an example of creativity outside the mainstream, right? Because Nollywood is as sort of non-mainstream as you get. It's a developing country. It's, and the thing that's really interesting, I didn't complete my slides, and sorry, I transformed these from Mac slides to PowerPoint slides, so they're a little messed up. But one thing that's interesting, if we look at developing country film production statistics, developed countries produce 6.3 films per million inhabitants. Developing countries on average produce 1.2 films per million inhabitants. So the vast majority of film production in the world occurs in developing countries. Why? Because traditional films are very expensive. And Nollywood approaches developing country rates because it has created this new model of more low-cost film production. But Nollywood existed or started far from the mainstream of creativity of the global entertainment industry. But as Nollywood matures, it probably is moving somewhere from the sort of margins to something that's not going to be quite like mainstream sort of Hollywood production, but something that's somewhere in between. Sometimes in copyright, when we talk about production, it rests on an assumption of mainstream creativity. I often get the comment, well, you couldn't have Hollywood films without copyright. You probably couldn't have many Hollywood films in their current form, but that's not the only thing that copyright needs to incentivize. So when we think about incentives and decision-making in terms of investment decisions of creators, we shouldn't necessarily assume that everyone makes a decision like an incumbent. I think one of the things that's interesting about Clayton Christensen's The Innovator's Dilemma is he talks about how sometimes incumbents don't see entrepreneurial or innovative potential around them, largely because of where they sit in relation to the entrepreneurial potential and where they sit with relation to the past. I think there's something to be said for thinking about creativity and innovation as basically involving people who are able to see cross connections between the old and the new. So Nollywood creators took aspects of Hollywood B-movies, aspects of Bollywood, and created them into something that was new and something that was really imbued by an African context. And I think as Isaac Asimov, there's a recently published article, it was just published last month, that talks about how do people get new ideas. And it really focuses on this connectivity in the sense of new things are partly by virtue of people seeing old material and looking at it in new ways. And I also connect this to Thomas Kuhn's paradigm shifts. He focuses on the fact that it's often new scientists that are new to the field, or young scientists that are able to sort of initiate paradigm shifts because they don't accept the old. They take the old and sort of imbue it with a new vision. And I think that has really important implications for how we think about creativity, particularly with respect to mainstream versus non-mainstream creativity, because a lot of creativity starts outside of the mainstream. And often people will use it in ways, and it may become mainstream, but that process of sort of marginal creativity or creativity outside the mainstream becoming mainstream or becoming something different is really important for thinking about how copyright affects creativity. And I think when mainstream meets the margin, we really need to think about how the dynamics work, because if mainstream always characterizes the margin as just being folklore, that has serious implications for what might be some of the most important sources of creativity. And I could talk more, but I've been told that I ran out of time. So, so thank you. Okay, you'll be here after. Okay, you can have slides though. Okay.
On the computers. So, this is a project I did a few years ago that actually a lot of people in this room helped out with. So, Dave let me crash on his couch when I had to go interview producers in LA, and both Chris's were very supportive and inspirational through all of this. And Aaron, I think you gave it to a class of students and they all wrote comments, which was really helpful. So, thank you. I hope you don't mind being associated by proxy with the topic now. I'm going to skip the lit review because it's basically why we are all here. But I will quickly speak about why I chose this industry as a low IP industry to study. And that's because even though adult content is protected by copyright, although some would argue it shouldn't be, it is in the US. It's been really, really hard for the industry to actually make use of copyright in recent years. At least that was my hypothesis going into this, because there's been so much copyright infringement online. And so my first research question was, is this actually true? And then the second question was, if this is true, then why are they still producing content and how are they still making money? And I also just want to note why I think that this is such a fantastic contribution to this literature, if I may say so myself. And that's because a lot of the studies that have been done in this field look at very close-knit communities that function through social norms. And I think that's fantastic and that's really important research, but unfortunately it's really, really easy for policymakers to dismiss and say, well, this is great that all these communities work, but actually this has no relevance at all for the major entertainment industries that we care about when we're talking about copyright policy. And so this industry does happen to be a major entertainment industry. It is worth billions of dollars in the US. It's been on the forefront of tech adoption and new media format adoption ever since the paperback book. It's driven photography, cable television, home video formats, broadband internet. They've developed new technologies like secure online payment systems. So, we have this industry and it's hugely important, it's innovative, it's fast-paced, and it has a lot of parallels to the industries that we do care about. So there's unfortunately very little research on it for reasons you can imagine. I honestly think that is really unfortunate, because if you have any interest in economics whatsoever, you should be fascinated by this industry. So, and that's, I should also note, that is, has nothing to do with whether you agree or disagree with social issues around the content. My project has nothing to do with the social issues, which is a point I need to hammer home every time I present this, unfortunately. But let's talk about economics for a second. Copyright infringement. When this content first started moving online, it was basically a gold mine. So one really interesting thing about this market is that consumers have very strong privacy preferences. So being able to consume within the four walls of their own homes was very convenient. But of course, the internet is specifically designed to share and copy digital files. So there was a lot of copyright infringement that started. But it wasn't just copyright infringement. Back in the beginning, the barriers to entry were so low in the industry that any idiot could come in and set up a website and charge $29.99. And so there were a lot of scams. There was a lot of malware, viruses. Not all of them showed you more of the content you wanted to see. Some of them, stole your credit card information. And so this also kind of pushed consumers toward copyright infringement or consuming content that wasn't from a legitimate source, because it wasn't only free, it also was a way to not have to leave a traceable payment method. But at that point, file sharing was still the dominant method to get content like that, and file sharing was pretty unreliable. You had viruses there too. You couldn't browse and preview content and watch it immediately, which tends to also be important in this market because consumers are comparatively impatient. And so the industry was still doing very, very well until about 2005, because what happened then was that the platform for YouTube was developed. And that was the game changer, because it spawned this network of so-called porn tube sites that are just like YouTube, but they're for adult content. So they look somewhat like this. Users could now browse content, access content immediately, legally from their point of view. There was a lot of pirated content on these sites, and so that was really the game changer that started making it harder to sell content. Now, why copyright was so hard to enforce? Sorry, this is really bugging me. I go into this in a lot more detail in the paper, the end user litigation problems with using the DMCA against the tube sites. But the main point that I just want to emphasize here is that in this industry, your average piece of content has the attributes of a commodity. So it's substitutable. Even if a producer of content can completely prevent you from accessing this content somewhere without authorization, it doesn't do them any good because you will just go watch something else. It's not like Walt Disney's The Lion King. You can find comparable content. There's so much free stuff out there now that, this is what really undermined the business model of creating and selling content. So the press is on it. The Economist wins the award for the worst pun in the title. A bunch of companies did start going out of business, the companies that were holding on to this business model of selling content, and so the press was like, oh, it's the death of the industry. I think that they were kind of forgetting how flexible and adaptive this industry is and has always been. So what my study ended up showing was that there are still some very smart players in the market who have shifted towards selling different kinds of goods, services, experiences, anything that's difficult to copy. So what does that mean? So for example, probably the biggest cash cow right now, or at least when I did this study in 2012, was live camera shows. So anything that's interactive, that gives people this experience of interacting with a person, is something that consumers are still paying a lot for, because you can't pirate that experience. You can steal the video feed, but you can't take the experience. And then producers have been looking into all sorts of other types of experiences that they can offer, such as gaming, virtual strip clubs, things of that sort. The other thing that consumers are still paying for is convenience. So for instance, the mobile market is doing very well, despite all of the hindrances of being banned from Apple products and so forth. And then the niche content market actually still functions with the traditional subscription model that used to be so successful online. So, and here it's more of a service-based thing that people are paying for, because you're essentially paying for the curation of content that is difficult to scrape together from the free stuff because it's so rare. And then producers have been looking into all sorts of other services that might be useful to consumers, like, for instance, having your library stored in the cloud rather than on your personal hard drive, and having that streamed to different devices and so forth. And so, but the really, really interesting thing here is that they're still producing films. They're still making this traditional content. Why? Because, well, for one thing, it serves as a basis for these other goods, but especially they're using it to give away as a loss leader. So what they're doing is they're making clips of content and they're branding it and they're feeding it to these tube sites and hoping that, through the branding, people will ultimately wind up with their company when they need any of the services or experiences that they're offering. And this works very well, partly because production costs are very low and the distribution costs are zero because the tube sites carry all the bandwidth and they get ad revenue. So that is interesting. The study concludes that we don't know whether the output is optimal in the economic sense in this industry. So just the fact that they're surviving doesn't tell us anything about the economics, but the fact that they are still producing content does certainly challenge one of the fundamental assumptions underlying our copyright policy, which is really simplified and does not take into account the fact that we could use loss leaders as an incentive to produce content or have this secondary market effect. So I will stop there because I know that we are running over. Actually, I'll go right into a question, if I may, because there's so much that 10 minutes or 15 minutes is just way too short, right? So one thing that struck me about what you were saying about Nollywood and also what we heard before about K-pop and stuff. So one parallel between all these things is that they're incredibly short product cycles.
Yeah.
And I wonder if there are parallels to Chris Brigman's work in the fashion industry there. That's actually not what I want to talk about. I want to talk about quality and production costs. So during my study, I learned that one of the reasons that for the adult content industry, production costs have always been low, even when there was full copyright protection, is actually because of consumer preferences. It turns out that there are entire genres of adult films that are bad on purpose. They have shaky cameras and bad lighting because it seems more authentic to people. And that just happens to be cheap. Also, in this industry specifically, like, no one needs a full-length feature film. I think the average that people watch these films is 12 minutes, said some study sometime from a hotel. So here, I'm wondering, so first of all, whether there are parallels to Nollywood movies, in that the early Nollywood movies were kind of cheaply made D movies, as you called them, because they didn't have a budget, but they were also really, really popular. So I'm wondering if maybe, one of the policy arguments behind copyright is that people need to be able to recoup their investments in order to have high quality content. But what if low quality is actually a consumer preference?
And I think that's a great question, because it actually makes me realize there are parallels between film and music. Because if you think of the first time you did an iTunes download, the quality of that song, if you actually tried to play it on a stereo, it really sounded awful. It sounded fine on headsets. But I think as technology changes, I think sometimes, I think industry incumbents sometimes are not willing to recognize that trade-off, because if you wanted to play it on a stereo, you couldn't, it would sound awful. But similarly with Nollywood, because people are watching them on very small screens. If you saw some of the old Nollywood movies on a big screen in a theater, it would probably be unbearable, because the picture quality, the sound quality is so bad. But if you're seeing it on your little computer screen or your television screen through a VHS or some other kind of digital recording mechanism, it's perfectly fine. So I think in some instances, they are responding to what consumers are willing to accept. Now the question is, as the industry matures, you're seeing that now Nollywood filmmakers are actually making films that the first science fiction film was produced maybe 3 years ago with, using, CGI. And so you're seeing much more expensive and high quality productions. Now I don't know, it's hard to tell how that's going to turn out, but my guess is you're going to see it sort of a bifurcated Nollywood market. Some will still be the low quality production that's exactly like the kind of films you talked about, and I think there's a market for that. And the other side would be higher end films that you could actually see on a big screen, that are more expensive and that require more upfront investment, and that may also require different levels of copyright enforcement, because those kind of films, if they're copied, you certainly won't get your investment back. The cheap, very quick films, you probably don't need a lot of time to get your investment back. But this is one of the things, when you talk to people in Nollywood, this is one of the things they're grappling with. They're saying, we don't have enough IP, we need more IP, and that will help us. But I think part of it is really recognizing market segmentation, responding to consumer demand, or creating demand in sectors that maybe bigger players wouldn't have thought of. I mean, no mainstream global entertainment industry player would have thought to make films targeted at the African market. They just, our African market, the market gets, like everywhere else, they just get films that are shown in the US and they get to see them maybe later. But I think it raises interesting questions, so I'll have to think about that more. I had a question for you, actually.
Go for it.
One of the things that you're, and again, I do work in music and film, so I'm really curious, because it strikes me that in music right now, we're seeing a real shift in consumer preferences to streaming. So it started with downloads. Apple iTunes became really dominant because of digital downloads. Apple just reported last month that their music sales actually fell for the first time since the launch of the iTunes Store, because consumers want to stream now. So it strikes me that, are we seeing parallel movements in the adult entertainment film industry? Because some of the trends you mentioned really aren't about downloads. It's about some kind of stream content that may or may not be interactive.
Yeah, it's true. Actually, the adult industry is credited with inventing high-definition streaming technology. So they were probably the first industry to move into streaming years ago. So, music industry, catch up.
Good luck with that.
But yeah, I think, yeah. No, it's interesting that this industry has always been, the first to actually adopt it's kind of like a bellwether for the other entertainment industries. I think we should be looking at it more.
But don't they, in a way, have to be because of the nature of their industry?
In a way, yes. So I mean, there are a couple different arguments as to why they're always on the forefront. But I mean, one of them is that they don't get any legal or policy support from anyone. So they don't really have a political lobby. So when things change, they need to adapt or they die. And they're very accustomed to working with that and working with red tape. So that's one of the reasons.
So can I ask one quick question for each of you, and this is a different question. For Kate, have you looked at all at the adult entertainment industry in other countries to see if their experiences have been different? And also, related to that, is the moment that you describe for adult entertainment today in any meaningful way different than the kind of adaptation to technology and market and legal regulation of other sorts that you've seen over a long period of time? So I was thinking of the stand-up comedian study where there's just a long iterative relationship between content, format, access, other kinds of legal regulation that produces the particular sort of market or normative practices in the space. So, adult entertainment has always been chased by zoning authorities. It's been chased by home entertainment as opposed to theatrical. The production quality has gone up and down over time depending on the perception of whether people would tolerate things longer than 12 minutes, for example. So that's sort of a cluster of questions about sort of what's special about the case that you're describing in the U.S. now.
Yeah. Okay. So to the first question about whether I've looked at other countries, I have not. I've focused only on the U.S. industry because it's actually the most easy one to study. It's very self-contained. It's very above the ground. There's a lot of legal regulation that people are complying with, and they have like a conference where everyone goes and you can talk to everyone at once. It would be interesting to look at other countries, in particular countries that don't have the same types of legal regulation that we do in the States. The other question, yeah, that's really interesting. So, I mean, for instance, in the stand-up comedy case, I mean, one of the parallels that I certainly see between my study and Chris's study is that with the change in the ability to enforce your intellectual property, the innovation changes. So as it gets harder or easier to enforce your or to appropriate your content, you kind of weasel your way around it in a way, and you invent a different type of good. So like in the stand-up comedy example, and correct me if I'm wrong, I think they shifted from having kind of generic jokes and investing a lot in performance to moving towards investing a lot in the actual joke content and less so in the performance. And what's really interesting about that is that it's really hard to evaluate whether that's a good or a bad change. It's different. And so similarly in the industry that I looked at, I mean, we're seeing a different type of innovation rather than a decrease in content.
So quick question for Funmi about, so you talk about sort of the outsider identity of the Nollywood community, and sort of the who controls and who has the power to make changes is a really critical variable. I'm wondering about the name Nollywood itself, and so who was responsible for that? Because the name itself has a kind of interesting valence in terms of its sort of status and character as a filmmaking community.
Yeah, and some people don't like it. It definitely patterns itself after Hollywood and then Bollywood. And I think that there's some really interesting, trail between Bollywood and Nollywood. So a lot of people in Nollywood look very closely to Bollywood, especially in some regions of Nigeria. So it's very interesting how influential Bollywood has been in Nigeria. I think the name, it gives a certain credibility. When you say Nollywood, people immediately know you're talking about a film industry. By the same token, it's an exact copy of the Hollywood name, and this is something I've heard discussed by people in Nollywood as well. But I think the name has stuck for better or worse.
So did the Nigerian community sort of appropriate it for themselves, or was it imposed, or was it sort of a combination?
I'm not sure I really know that. I mean, I think people within Nigeria at this point do use the term Nollywood. That's an interesting question. I'll have to ask some people that have been around longer and see what their take is on that, whether it was first introduced internally or whether it was absolutely external. My guess is probably internally, because Nollywood had been going on a long time before people outside of Nigeria or Africa actually knew anything about it.
So I do not want to stand between all of you and lunch, so we have time for one more question.
Funmi, I was really struck by some parallels between the story you tell about Nollywood and the story that we often hear about the early days of the U.S. publishing market, which thrived, grew, existed because of piracy. And then at some point, there was a decision that this industry wanted to make more complex work, wanted protection for, wanted national treatment, right? So, and at that point, IP protection became something that they wanted, as opposed to simply existing through piracy. It doesn't map as well, I think, to the adult film industry, but I was wondering if you could comment on that sort of mythology, or the way that maps to the U.S. mythology, and whether you see any connections there, Kate.
So I would just say I think that highlights sort of what I call a multiplicity of creativities. They're different styles and industrial ways to organize from an industrial perspective creativity. I think in the U.S. case, one part of the shift was sometime in the late 18th century. Some of that I think was connected to the fact that during that time period, the U.S. shifted to becoming a net exporter of music, because the recording industry, the U.S. music came from Europe for much of history in the United States. Wasn't until the late 19th century and really the early 20th century when we started to see, especially like the ragtime craze, blues, then jazz. The U.S. by 1910, 1920 was a net exporter of culture, and that made a huge difference for how U.S. Industrial interest thought about copyright. Before that, when the U.S. was a net importer, people were happy to copy. When the U.S. started to become a net exporter, people said, well, wait a minute, copying maybe isn't so good now that you're copying us. So I think the trajectory in Nollywood appears to be somewhat similar in that as Nigeria becomes an exporter of culture, unexpectedly, and with no one being able to realize that's what would happen, I think people are starting to say, we need copyright protection. And I know last year I had met with people in the industry in a couple of different meetings, and it's really interesting to hear them talk about how lack of copyright really impacts them. And this is something that 20 years ago no one would have thought about in Nigeria. We take for granted that sort of entertainment industry interest help shape copyright. That has not been the case in Nigeria. And when I was involved in some industry meetings with different industries in Nigeria, they basically said, well, people haven't really asked us what we need from copyright law. So that assumption of how law is created is certainly true in the United States. It's not true in much of Africa, for reasons I can't go into in this paper, but I'm working on it in more generally.
Yeah, so I guess it's interesting when you talk to producers because, and how they feel about all of the piracy that's happened over the past few years, because some of them are a little bit bitter about it, and they're like, well, I guess we just have to, change. And some of them are like, this is awesome. This has massively increased our, potential customer base because our stuff is getting out there. What I do know is that unlike the publishing industry, unlike the fashion industry, sorry, I keep referencing Chris Springman, I just think all of his work is amazing. But unlike all these industries, they know that they can't, ask policymakers for copyright protection. That would draw attention to their industry and probably lead to the opposite. So, they're gonna roll with it.
So I guess the one parallel is no one asked them yet, or maybe never will.
Yeah. They probably hope that no one even looks in their direction right now.
So lunch is, let's have a hand for our last